case. So today you'll be hearing from Kelvin Tanner from Charles Russell Speechlys. He'll be running through access to talent. So he'll be running through the new immigration system and everything you need to know as a games business in terms of recruiting international talent. After this, you'll be hearing from Tim Davies from Sheridan's. He'll be discussing any changes to accessing European funding, such as Creative Europe, or any impacts on domestic funding as well. After this, we have Sally Brisson from Mishcon Zareya. She'll be talking about changes to copyright and IP law that you should be aware of. And finally, we will conclude with Liam Price from Sheridan's, who'll be talking about data flows and data adequacy and so on. At the end of all of these presentations, there will be an opportunity to ask any questions you'd like to the panel. So you can do this through a couple of ways. You can either submit a question anonymously through the Q&A box, or you can use the raise hand feature and come on your video and audio and ask a question directly. But feel free to ask questions throughout the panel. They can answer them at the end of the presentation. So with that being said, Kelvin, are you happy to kick things off?
Great. I'm just going to share my screen and hopefully that will work. Is that anyone give me a hands up just to say that that's people? Excellent. Hi everybody, I'm Kelvin Tanner. I'm a partner in the immigration team at Charles Russell Speechlys. So I'm going to try and give you today a kind of bit of a whirlwind tour of some of the things you need to think about from an immigration perspective in the run up to the end of the transitional period on 31st of December, introduction of the new immigration system, which actually went live today for non-Europeans and from the 1st of January for Europeans. And a few of the other immigration categories that may be of assistance kind of alongside the new skilled worker route. So looking first of all, before we go into the new immigration system, is making sure that everybody's aware of the EU settlement scheme. So this is the scheme that was introduced for European nationals and their non-European family members who were in the UK before Brexit or before the end of the transitional period on the 31st of December, who are eligible to be granted status in the UK and to sort of protect their position going forward. This is really important because many of you will be recruiting or employing EU nationals who entered the UK before the 31st of December, and they now are facing a relatively kind of close deadline to make applications under the scheme. So for everybody that entered before the 31st of December 2020, the ultimate deadline to apply under the scheme is the 30th of June 2021. Anybody who has been living in the UK for a period of less than 5 years when they make their applications is given pre-settled status. This basically means that they're given permission to remain in the UK and can their right to work and to be self-employed, study, or just live in the UK is protected for that 5-year period. And then once they've completed a continuous 5 years of residence, they can qualify for settled status. Anybody that's already done a continuous 5-year period will be able to immediately apply for their settled status. I think the key thing here is it's not too late for Europeans who want to come to the UK to enter. They can do so until 11 p.m. on the 31st of December. If you have people that you're going to be bringing to the UK or maybe bringing to the UK, I think the first point is that you can bring forward the date that they move to the UK and get them in under the pre-settlement scheme. That means effectively they have a right to work without you needing to go through the new immigration system, which, as I'll come to in a moment, is significantly more expensive and is a lot more kind of administratively burdensome than the current provisions. So that's something to consider. But anybody who is an EU, EA or Swiss national who is arriving in the UK and wants to begin work from the 1st of January will need to qualify under the new immigration system. So the main kind of limb of the new immigration system is the skilled worker route. Now this is basically replacing what people may hopefully be familiar with, the Tier 2 general system. It's basically a system of sponsored work visas where an employer, usually a company or organization, applies for and obtains a sponsorship license that gives them the ability to sponsor skilled workers in the UK. The same scheme is going to be operating, and anybody with existing Tier 2 sponsor licenses will, if they log in today, which is the sort of day that the system goes live, find that that's been converted to a skilled worker and to an intra-company transfer route license. And that's the system that's going to be used going forward. Any companies or organizations that may need to sponsor European nationals or non-European nationals in skilled roles from the 1st of January 2021 should consider applying for the license if they don't have one already, so that they're ready and able to sponsor people when they need to. In terms of the new routes, I think there is some good news. So the good news is very much in relation to the system, particularly for those who are used to sponsoring non-Europeans. So in the annual cap on skilled workers coming into the UK has been removed. So there's no longer a limit on the number of skilled worker visas, or what was tier 2 general visas, that can be issued each year. It's now much easier to switch in country into the skilled worker route. So previously you had people who were here on one visa, they would have to fly home, sometimes, back home to say Australia or New Zealand, have to make a new application, wait until the new one is approved, fly back again. And aside from the kind of, I guess, the carbon footprint that creates, it was quite a challenge for employers and for the employees. Now there's going to be a lot more provision for switching in country, which is really good news. The resident labour market test has been abolished. So this was a process whereby before you could sponsor a tier 2 visa, you had to demonstrate that you had advertised the vacancy to the resident workforce for 28 days and showing there were no suitably qualified settled workers. This is not that there is no longer any form of kind of recruitment or kind of requirements to be shown, but as long as you can show you have a genuine vacancy, the person is genuinely sufficiently skilled for the role, then you don't need to go through the same very formulaic resident labour market test. The restricted certificate of sponsorship process has been changed to a designated certificate of sponsorship process. The key difference is that we should receive decisions on designated cause applications within 24 hours. Previously, it was done on a monthly basis. So there's a lot more ability to kind of be agile and quickly if you need to sponsor skilled workers. And there's no longer a restriction on owning more than 10% of the issued share capital of the sponsor. That was problematic where business owners were moving to the UK, as there were limited routes available for them. And then that should really, for kind of entrepreneurs and business founders, give a bit more flexibility on the options that are available. The minimum salary levels have been reduced. Not significantly, but they have been reduced, and there is still quite a bit of flexibility for people to be qualify on slightly lower salaries for shortage occupation roles where you have relevant PhDs for students and people switching as new entrants into the skilled worker route. And the minimum skills threshold has been reduced quite significantly. So from degree level to A level, which has opened up a far wider range of roles that can be used for sponsorship. So in future, it will be easier to fill vacancies with migrant workers, albeit you'll have to go through this quite complex process, which will now apply to Europeans as well. So comparatively for sponsoring Europeans in those roles is going to be more costly, and there remains no kind of route dedicated to low skilled workers, so that depending on who you're employing, perhaps less so for kind of gaming companies, but I think generally that's one of the challenges that employers will face. The shortage occupation list still lists programmers and software development professionals as a shortage occupation role. That's good news insofar as it means that there will be lower application fees and lower minimum salary requirements to be met. And the route still leads to permanent residence after 5 years. The intra-company transfer routes, if people have previously made use of those, will continue broadly as they are now. I think the key distinction is that the cooling off period that used to prevent you having two sets of sort of tier 2 leave within 12 months of each other has been a change, and you can now basically come and go on tier 2 intra-company transfer visas as long as you're not out for more, so as long as you don't hold that visa for more than 5 years in a six-year period. So there's a lot more flexibility for short assignments. I think the key things for employers are you need to anticipate those increased costs if you are now using sponsored visas for European hires, and also for a broader range of roles potentially. In the future, the government are also looking at bringing in a self-sponsored skilled worker visa, which I think will be very popular. They're still consulting on how that will work, but that may provide an alternative work visa route outside of sponsorship, particularly where, if companies don't have sponsor licenses, smaller companies may be able to make use of that. Other good news for employers and also for students studying in the UK is that a new post-study work route will be introduced for those graduating from the summer of 2021, and it will allow people to basically remain in the UK and to qualify for a visa that allows them to allows them to work for a period of 2 years. It's not a visa that can be extended, and it doesn't lead to permanent residence, but it can be used as a sort of stepping stone to switch into the skilled worker route, or potentially into one of the sort of entrepreneurial routes that are available. And it gives employers the ability to kind of easily or more easily employ people out of university, have a bit of time to kind of, almost to assess them and decide whether you want to sort of take that next step of sponsoring them, knowing that there are additional costs and responsibilities involved. There's no real guidance been published yet on that route, but that should be published, before people become eligible to apply next summer. I'm going to quickly mention the startup and innovator routes. So this is basically, these are the categories that replaced Tier 1 entrepreneur visas for those looking to establish a company in the UK. I think the key thing is they're very, very good visas, but only for the right type of applicant. So it's basically for people that want to found an innovative, viable and scalable business. And they need to be endorsed by a designated endorsing body for their kind of innovative, viable and scalable idea. So it really depends on kind of what people are looking for in the UK and what they're planning to do. But for the right people, this provides a good route for people that want to establish a company. And then the other, I think, useful one to mention is the Global Talent Visa. And this is used quite a lot in the digital technology sector because Tech Nation are an endorsing body, so they can endorse people who are either world leaders in the digital technology sector or potential future world leaders in the digital technology sector. So if you have really, really high caliber people, the advantage of this visa is it gives them a right to work or to set up a company or to kind of do a combination of those things. So it's less restrictive than being on a sponsored work visa. And is, I think, something that if you're not already aware of, it's worth bearing in mind for some candidates. Now, this is again to go through very quickly. So just to say that most of these visas do, for your employees, lead to permanent residence in the UK. So the innovator, so startup and innovator categories and the global talent category can lead to permanent residence as quickly as 3 years. Most of the people on skilled work visas and people applying under the settlement scheme who don't yet qualify for settled status will get to permanent residence after 5 years. And the key thing is that you shouldn't be absent for more than 180 days in any rolling 12-month period in order to qualify for permanent residence. So that can break your residence. So if you have people that you know are traveling very extensively, that's something that could impact their ability to eventually get permanent residence. And you should at least make sure they're aware of that and the implications of that. And then finally, there is a route to permanent residence where you've been lawfully resident for a continuous 10-year period. And that can be kind of made up of a combination of different immigration categories. And then finally, for those that do get to permanent residence, there's the option of then naturalizing as a British citizen. Usually you can do that after 5 years, and you must normally hold permanent residence for at least 12 months. If you're married to a British citizen, you don't need to hold permanent residence for 12 months. You can apply once you hold indefinite leave to remain. And there is quite a strict residence requirement for naturalization. And the reason I mentioned kind of ILR and citizenship is because once you get to indefinite leave to remain or permanent residence, you're not subject to immigration control, and there's no restriction on the work that person can do for you in the UK. And likewise, obviously, once you're a British citizen. So often employers want to make sure people are on that track eventually. So that's extremely kind of quick and high level, but hopefully sort of sets the scene of some of the things to be aware of about the new immigration system and things to think about as you prepare for Brexit. I think questions will be coming at the end, so I'll move on from that. And I've included my details in case anybody has anything more detailed they'd like to discuss. And we'll now try and stop sharing if that's possible, and hand back to Grace.
Brilliant, thank you, Kelvin. Like Kelvin said, if you've got any questions related to immigration or recruiting international talent, feel free to pop them in the Q&A box or ask them at the end with the hand raised function. Next, we'll have Tim from Sheridan, who will be discussing access to funding.
Thanks very much, Grace. And thanks for Ukie and yourself for putting this on today. Obviously, it's more important than ever with the uncertainty that's coming up at the end of December. Sadly, I don't have any nice slides to share, but I do have some stuff that I've already prepared, and I can put them in a slide or nice, attractive format that Grace can then share either via the Ukie website to anyone who's attended today. So obviously talking about funding, I think this will be a relatively short and sharp part of this whole presentation, because I think there's still a lot that's unknown, but what we do know in terms of Creative Europe funding, is pretty clear cut at this stage, unless the deal is going to be reached before the end of the transition period. So first things first, for any developers that have funding either from a publisher or any other third party, really, whether they're based, whether that money or that funder is from the EU or elsewhere, it's worth just checking if there's any anti-Brexit provisions that allow the funder or investor or financier to get out of providing you the money for that particular deal. We would expect that it would be extremely unlikely for that to happen. It would also be extremely unlikely, we would have thought, for Brexit to have been classed as a force majeure event that would allow a funder to get out of funding a deal for the development of a video game, purely because it's really unlikely that the development itself is going to be affected by any kind of like cross-border action or any tariffs that might be put in place. Although there might be barriers in terms of exploiting games down the line, in terms of a funding and development aspect, that should hopefully continue relatively unimpeded. So for future UK funding, so in terms of things like the video games tax relief and research and development tax reliefs, and those two schemes, they should be continuing post Brexit on very much the same terms that they are on today. We know that video games tax relief has been recertified until the 31st of March 2023. And either after that time, it will be we'll see whether the UK government will either, make the video games tax relief scheme even better and even more improved, because it won't be bound by the state aid rule, or probably won't be bound by the state aid rules that currently restrict how much relief that those schemes can both provide. And the obvious hope is that, after Brexit, if the UK isn't part of that state aid scheme, which restricts how much money a UK government can provide to various companies within that state without it distorting competition between the other EU states, then the theory is that obviously they could make the video games tax relief scheme even better. But I think we'll have to wait until end of 2021, 2022, until we find out whether that's going to be the case or not. So for the time being, the video games tax relief will stay very much as it is. And that scheme at the minute obviously also does include, or does allow for, EU spend and costs to be incurred as part of the relief that's claimed. And it isn't thought that that's going to change in the time being. And I briefly touched on the EU state aid rules. So this is one of the big sticking points in terms of the Brexit negotiations at the minute. Obviously, the EU still wants the UK to be bound by those rules. Naturally, the UK doesn't want to be. So until what happens, effectively, the UK is going to be bound by the current state aid rules until the 1st of January 2021, after which time, in theory, if we haven't reached a deal by then or afterwards, then you could see that those video games tax relief and R&D schemes and any other state aid relief scheme is improved. Other funding options, so that might be other investor-friendly schemes such as EIS or SEIS. There's nothing that would indicate that they are going to be removed or taken away from developers who want them or who are currently using them either. So again, depends on what happens in relation to state aid, but both of those schemes could also be improved. The one big negative to obviously Brexit is going to be the removal of Creative Europe funding. Creative Europe confirmed earlier this year, ahead of the previous Brexit deadline of 31st of March, that it was, if for any studios that have received Creative Europe funding this year, they will continue to pay that in respect of projects, even if those projects aren't completed ahead of projects created or being developed by UK studios, that is. Creative Europe has confirmed that they will continue to pay any funds or fund those projects for UK studios even after the Brexit deadline. We will see in terms of any future European funding, depending on what happens with the Brexit negotiations, whether the UK is part of any Creative Europe or similar Creative Europe funding schemes. But at the minute, that looks very likely, as Grace mentioned, with a no-deal Brexit looking increasingly likely. And post-Brexit games development, obviously with the loss of Creative Europe is going to be quite large, especially for a few studios that have really used it quite well over the few years that we've had access to it. But there should be very little changes in terms of how people invest in UK companies, and in terms of the tax relief and other tax and the schemes available to UK companies. Companies such as Creative England, UK Games Fund, because they're coming off their funds that are provided by the UK government, they should remain in place and will continue to remain in place. Again, as with the state aid rules, you might see that those grants and fundings increase so that the benefit to UK studios is even better than it is currently. Sadly, it's a lot less clear cut in terms of what's going to happen here, in terms of obviously with as Kelvin's just mentioned, in terms of the immigration, there very much seems to be fleshing out what's going to be happening there. In terms of the other funding stuff and with what's going to be happening, we're very much waiting and see what's going to happen. The theory will be that if the UK isn't part of that state aid scheme, then everything could be better. But equally, the UK government might do away with VGTAR and R&D altogether. Although I think we'd be surprised if they did do that, given how well it's done and the scheme, how well that scheme is doing. I will just do a quick plug for the team at the BFI, who are obviously administering the cultural test part of the VGTR scheme. If you have any questions on VGTR or helping pass that cultural test, please get in touch with them. They are obviously extremely busy, and they're seeing a massive uptick in terms of developers applying for video games tax relief, but nevertheless they remain incredibly helpful, and they're an incredible credit to the industry itself. So please do obviously reach out to them if you do have questions on the application part of it. And that's really all for me. It's a very, very short and sharp presentation, as I mentioned. I will put some slides together for Grace to distribute around, and if there's any questions, please obviously feel free to post them in the Q&A.
Great, thank you, Tim. And in case any of this is information overload right now, each of our panelists have written an article on their respective topics, which will be uploaded to our website as well after this webinar. And like Tim said, we'll also be sharing the presentations from today as well. So next we've got Sally, who'll be discussing copyright and IP.
Okay, great. Hi, everyone. I'll just try and share my screen. Okay, hopefully that's worked. Sorry. Okay, I think that's worked now. Okay, great. So actually, I'm going to talk about intellectual property and the end of the transition period. So a very quick overview of key things that you should be aware of. Actually, you'll be pleased to hear that not much is changing in relation to copyright. It's actually more about trademarks and designs and the EU-wide rights that many people have relied on as cost-effective protection across the EU. So EUTMs and registered community designs. In summary, after the 1st of January 2021, they won't cover the UK. So when looking at filing new rights, you actually, instead of considering whether you file an EUTM or a UK right, if the EU and the UK are of interest, you'd actually have to file 2 applications. The good news is that we're not heading into the unknown in the previous kind of scenarios with a no deal. The UK EU withdrawal agreement does actually provide a number of mechanisms to ensure that EU IP rights are protected through cloned rights, and also there are a number of provisions around disputes, so you can plan in relation to that as well. But as we say, basically we're advising all of our clients to kind of prepare and get ready for the 1st of January 2021. So what's a comparable UK right? So I'll also call it a cloned right. In effect, on the 1st of January, all of the registered EUTMs, unregistered community designs, and international registrations designating the EU will be cloned onto the UK register. So that means you'll get a new, automatically a new registration. It'll have the same legal status as if it was applied in the UK. It'll have the same priority and filing date. And it will be an independent right that can be challenged, assigned, licensed in the same way as any other right. The key thing is you won't be notified about these rights. So to the extent that you don't have representation or you don't have an agent, you'll need to look at the UK register after the 1st of January to identify the rights that are being created. Cloned UK rights, I mean, what's the impact? Well, I think the idea here is to kind of show you what we're going to see is in the UK at the moment, we've got about 750,000 UK trademark registrations on the register. Overnight, we'll add another 1.4 million. And we'll suddenly have a kind of, much larger kind of registry. And that means that there already has been a 30% increase in disputes at the UK Intellectual Property Office following, the initial vote when UK filing increased, and we can expect many more disputes going forward. Something that may trip you up in relation to the cloned UK rights that are being created is that they need to be renewed separately at the UK IPO. So you may rush to renew an EU TM now that's due for renewal in the next 6 months, which you can do so. So if it's due for renewal in February, you might renew it and it will show as renewed on the EU register. However, it won't have been renewed, the comparable right won't have been renewed in the UK, so you need to budget for a separate renewal and look out for that. Many people might miss those renewals, so the good news is that the UK IPO is allowing 6 additional months, but it is important that you note that deadline, as I say, and note the new rights. In addition, if you haven't managed to renew the EU right at the time, and it's within the kind of the 6-month grace period, you can actually also have a period of time to renew in the UK as well. There was some uncertainty about the applicability of these cloned rights and EUTMs and RCDs to agreements that you might have in place. And the UK government has tried to give some reassurance in the withdrawal agreement by stating that agreements relating to EUTMs and RCDs, if they're in existence before the 31st of December 2020, it'll also cover the comparable UK rights. But of course, this also depends on the terms of the agreement and also on the governing law. We don't quite know what the position will be in terms of the interpretation of those agreements in the EU. And in general, the EU's position is that the UK is out of the EU. And therefore, whilst the UK's position is that the EUTM obviously will have a cloned right and it will cover the UK, you might be in a position that it doesn't actually cover the UK after the 1st of January. And we do expect some litigation to result as a consequence of that. It will be important for you to notify licensees of the new right and check its creation doesn't breach any agreement. So you might have coexistence agreements in place with third parties that oblige you not to register certain marks in certain jurisdictions. Well, you might be doing that by default, so just check. You can clone out of the new, so you can actually opt out of the new rights that are created, but do think about the implications on the agreements that you've entered into. And check your agreements generally. It was often the case that we thought that the EU, or generally we thought the EU would expand, not contract. So particularly in agreements, you looked at definitions of the EU that suggested the EU plus any territory that the EU is its comprised from time to time. Well, that would mean that maybe the UK drops out. So do think about that. And also think about registering license and security interests in relation to the comparable UK rights at the UK IPO. But also to do that, you need to have done the appropriate registration at the EU IPO before the 1st of January 2022. There is also some clarity in terms of ongoing disputes at the EU IPO, and I think the key thing for you to be aware of here is just that if it previously was possible to challenge an EU-wide right based simply on rights in the UK. Now, if that dispute is ongoing and you just challenged right based on UK rights, and if it's ongoing after the 31st of December, the dispute will fall away. If it was relying solely on UK rights, then those rights will no longer apply in the EU, and the EU IPO will dismiss the dispute. So do think about resolving disputes before the 31st of December if you are relying solely on UK rights. In relation to ongoing oppositions at the EU IPO, that opposition will continue, but there could also be a cloned right in the UK. So what you need to do is watch the UK register and consider whether a new application is filed in the UK, which is possible to do for a 9-month period after we leave, after the 1st of January 2021. But you'll need to watch that and file a second opposition against that new application. But there are significant differences between EU IPO and UK IPO proceedings as well that you need to think about. And most significantly for you is actually UK IPO proceedings are much more involved and much more akin to litigation than the EU proceedings, which are much more paper-based. Position at the UK IPO and in general the kind of theme is pretty much kind of a status quo. The UK IPO is keen to kind of give reassurance to rights owners, and therefore the oppositions and cancellation actions based on earlier EU rights will continue on the basis of the UK Trademarks Act as it stood on the 31st of December. So they will acknowledge and continue based on just simply EU rights. That's what they've stated. So a slightly different position at the UK IPO. Something that you also need to consider is EU domain names. So you may have relied on them. Not many people have actually. It hasn't necessarily taken off as the most popular route for domain name registration, certainly for the clients that we deal with. However, there is an eligibility criteria and various notifications have come out in relation to domain names. So if you are a UK citizen residing in the EU or an EU citizen in the UK, or you have an established place of business in the EU, you can have an EU domain name. If you don't, you can't. And you need to make sure that you're taking steps to demonstrate compliance in relation to .eu domain names. Otherwise, they will be withdrawn and they won't work for website and email on the 1st of January 2021 and then be revoked a year later. So that could have a significant disruptive influence on your business if you are relying on a .eu domain name. Look at trying to comply with that requirement. Look at obtaining an EU address to comply with that requirement. Something perhaps less important to you, but obviously in the games industry, that you would deal with actually quite a lot of enforcement for clients in this industry. Physical enforcement. I won't touch on this for long, but essentially there is an ability to kind of raise your profile with the customs authorities by filing applications for actions, AFAs. You used to previously, a bit like the EU-wide rights, you could file a form and it would apply throughout the EU. But quite simply, after the 1st of January, if you filed it in the UK, it will only apply to the UK. And if you filed it in the EU, it will apply to the EU. So you need to file new forms to cover both jurisdictions, and you can do that now. Also, in relation to exhaustion of IP rights, something to think about in terms of, for example, distribution agreements that you may have entered into. The position at the moment is that, so IP rights, if you put a trademark, if you put a product into the market in the EEA, the IP rights will be exhausted. That will still be the position if the rights have been exhausted prior to the 31st of December 2020. But if you put a product onto the market in the UK and then seek to export it into the EEA after the 1st of January 2021, you're likely to have to seek the rights holders' consent to do so. However, we have indicated that at the moment we will accept EEA exhaustion, so products put onto the market in, say, France, will be able to be exported into the UK. The government said it will review that, but something to bear in mind if you perhaps have entered into any agreements relating to rights, perhaps with someone in the UK or someone in the EU. As I said, and nearly coming to the conclusion of this kind of short canter through the kind of various changes in IP, there's no change to the substantive copyright law, at least in the short term, and we do expect some divergence in the UK as a result of Brexit, because the relevant directives are implemented into UK law, and we are a party to various international copyright treaties. But you do need to think about things like reciprocal cross-border arrangements, such as portability of online content, which will fall away. So what are the key steps that we'd recommend that you take in relation to your IP portfolio? So it's just really actually, making sure that you are aware of your rights and they're in good order. So audit your filing strategy and use of brands, and consider where you're using and filing those trademarks. You're dealing with 2 jurisdictions now rather than 1. Ensure that the EUIPO records are up to date. When you get those claimed rights, they copy all the details entirely, so you're going to have to update details in 2 registries. Duplicating the cost. Deal with that now. You need to budget for increased renewals, filings and disputes, again, because you've got more rights in place. You need to review your agreements. We're not necessarily saying go and renegotiate them, but be aware of any weaknesses or opportunities in relation to the territory, relevant right and related provisions. Think about the impact on disputes, the fact that you may have to have more disputes in the UK IPO, you may have vulnerability or you may have opportunities. And set up watching services and look at your clearing strategies just to make sure that you don't miss any of the new rights that are being created. So that was my very brief summary, quite quickly. There's a lot of kind of technical aspects to this. I mean, if you have, you're working with an agent, also the UK IPO has lots of resources, and obviously I'm happy to answer any questions that you may have.
Great, thank you so much, Sally. I can see some people have already started to ask questions in both the chat and the Q&A box, which is great to see, so let's keep them coming. Next, we have Liam Price, who'll be talking about access to data.
Hi, yes, so I'm Liam Price. I'm an associate at Sheridan's, and I work across the games and data legal teams there. No slides from me today. But as Grace mentioned, there is an article coming out in due course from us, which also covers the same area that I'm going to go through at a canter today. And you can also reach out directly if you need any help. Before I start, a big thank you to Ukie for having me today. And apologies in advance for any background noise, disconnections, or my falling phone that might happen. Please bear with me if that happens. So I'm going to walk through a brief overview of points to consider in the context of your data processing activities, data protection compliance, and focusing in particular on transfers of personal data between the UK and other territories, taking particular account of the possibility of a no-deal Brexit and the transition period, which is shortly coming to an end. Just a note of caution, this is not intended to be direct legal advice, but I hope it's really useful in getting a handle of the area, and hopefully it gives you a steer on points to be thinking about. This is a very complicated and challenging area, and it is quickly changing as well. And so I'd really recommend that you do obtain legal advice on it, particularly if you've not obtained any advice on your data processing activities before. At Sheridan's, we're happy to help on anything like that, as and when you need us, do just reach out. So getting to the content now, I'm going to chat through some areas to be keeping in mind from a data protection and e-privacy kind of legal compliance perspective. And as I said, that will be particularly focusing on Brexit, the potential
I'm sorry to interrupt, but it appears to be
the points I'm going to briefly chat through will include the changes that could impact on. Is that slightly better at all?
I think it might be best if you turn off your camera, mate. That might help the connection.
I will turn off my camera.
That's possible, and then just speak through the audio.
Sure, sure.
It happens. Classic Zoom.
Ah, classic. Is that any better at all?
I think it is actually, yes, yeah.
Okay, perfect.
Sorry,
well, you will have no video from me, but you'll have my audio. So just to recap that, the last thing I mentioned, I'm just going to chat through some areas to keep in mind from a data protection legal compliance perspective, and hopefully that will help prepare your games business for the possibility of a no-deal Brexit. And so the points I'm going to canter through briefly today will include changes to the legal landscape, how a no-deal Brexit could impact on data transfers, a recent court case in the area, and commercial points to be thinking about that might be helpful for your preparation for a potential no-deal Brexit. Now, as you might know and be very familiar with, data can be one of the most valuable assets in your business, but unlawful processing of the data can present a really significant legal risk. A no-deal Brexit scenario presents some really heightened challenges to keep in mind in this area, particularly in regards to transfers between different territories and maintaining your compliance with the law in those areas. A top level point to be kind of aware of is that the GDPR, so the General Data Protection Regulation, will no longer apply in the UK directly after the transition period ends. However, the UK will, in a means, be applying its own sort of UK GDPR equivalent, and the provisions of that kind of UK GDPR broadly do have equivalence. That will apply alongside the UK's Data Protection Act of 2018. And so the top level point to be aware of, first of all, is that the principles, the rights and obligations on your business, as you might already be aware of under the GDPR, at least in the short term, should very broadly remain the same as they are now under the European GDPR. So moving on to Brexit and data transfers between territories. This is one of the most pressing issues for games businesses to consider in the context of Brexit and a potential no-deal Brexit. And it's in the context of data transfers such as from an EU or EEA country to the UK, and how they will be treated, and compliance measures that you can put in place or should put in place to ensure the compliance of those transfers. After the Brexit transition period ends, the UK is going to be a third country for data protection legal purposes. And that means that transfers of personal data from the EU to the UK will be prohibited unless some means of appropriate legitimization or a measure or protection is put in place for legal compliance. So a good way to approach this area is to try and prepare for the worst to the extent that you can. The UK may or may not be granted an adequacy decision that I'll explain in just a few moments. And so you need to be considering putting in place alternative legitimizing measures to help protect and legitimize your business and the lawfulness of any cross-border personal data transfers that you might be involved with. Just coming back to what I mean by adequacy decision there, it might be the case that the UK receives something called an adequacy decision from the European Commission, and that could happen by or before 1st January 2021. If the UK does receive an adequacy decision, that means that the UK will be treated as though it offers broadly equivalent protection for individuals as compared to EEA territories, and it will make your legitimization of your cross-border data transfers much, much easier. However, it's not guaranteed that an adequacy decision will be granted for the UK, although there are some positive noises kind of being made in different places on that. So moving on to some case law in the area. If you read into this area, you might be familiar already with a recent case from the European Court of Justice that's referred to in shorthand as Schrems 2. And that came out in July of 2020 from the European Court of Justice. And it concerned, one of the main points concerned transfers between territories, in particular over to the US. And in that case, in Schrems 2, the EU-US Privacy Shield method of legitimizing data transfers was found to be invalid, and a degree of doubt was cast over some of the other legitimizing measures for cross-border data transfers, including standard contractual clauses. As of today, standard contractual clauses are still legitimate, and they work as contractual terms between organizations that are prescribed by the European Commission, and which can be used as a measure to help you legitimize the cross-border transfer of personal data. As I say, after that Schrems 2 case, they're still valid, but some caution now does need to be applied when using them. And we would suggest not relying solely on them, but also considering additional steps, such as identifying whether alongside those clauses, any more supplementary measures might also be needed, and perhaps also consider undertaking a risk assessment of that data transfer, if that's relevant for your business, to consider what's happening and whether there might be some other appropriate measures that you can put in place to help assist with privacy protections for the individuals whose data is involved, and also to help further legitimize the transfer that you're doing there. So moving on from that onto commercial impacts on your business and how that might tie into the changes in the law in this area as we move into the post-transition period. Your business partners in EEA territories might start to get closer involved or crack down in a way on this area in terms of contractual provisions with you, and they might require that any personal data processing that's relevant to your arrangements with them is restricted to happening only in EEA territories and not in the UK. It might just be a point for discussion that comes up with some of your continental business partners. And those business partners might also be willing to accept that the processing happens in the UK, but they might require some forms of additional assurances or protective measures or provisions in the contract. So it may well be an overall discussion with your partners about putting appropriate kind of measures and steps in place. And overall, for your business as well, you may want to consider whether it's necessary for you to restrict personal data processing to being within specific local EEA territories, and perhaps just not applying the level of kind of free transfer of data between the UK and European territories as readily as you might have done in the past, and just focusing in a bit more detail on those areas and what your overall plan is. As regards transfers going in the other direction, so data transfers going from the UK to the EEA, the UK Government Department for DCMS, so Digital Culture, Media, Sport, have indicated that personal data transfers going in that direction from the UK to EEA territories should continue as is in general and won't be overly interfered with in any way relating to Brexit. And so that's hopefully some comfort for games businesses here. So just to kind of move on to a few points of what you might consider doing to help your business kind of prepare on this area. As I mentioned at the beginning, do consider obtaining legal advice on this because it's a very complicated area, as I hope you appreciate. Do also consider reviewing the personal data flows that are involved with your business, and that might include your staff, any branch offices, your suppliers, the customers that you have in the players of your game or games. And then also consider, and again, this might be something for you to discuss with your legal advisors, but consider entering into measures such as standard contractual clauses with any European partners or entities that you might work with. And that might concern how you are transferring personal data cross-border with those partners. And what else is there for you to consider as well? Well, of course, post-Brexit, you may want to take a look at your privacy policies and your privacy notices and just see whether they might require an appropriate update. You may also be required to appoint an EU representative for data protection purposes. And that would be the case if you don't have a branch in the EEA, but you do offer goods or services to individuals in the EEA, or you monitor the behavior of individuals in the EEA. So to give you an example of that, you might offer a game, across multiple territories, which involves data collection from players, and that might involve monitoring their behaviors. If that's the case, you may need to give consideration to appointing an EU representative and to that whole area. This is a very quickly evolving area, and the news over the next few months, such as whether or not the UK is granted an adequacy decision from the European Commission, could have big implications for your business plans and the measures that you need to be putting in place. However, our overall suggestion would be to kind of plan for the worst and put in place measures, assuming that an adequacy decision wouldn't be granted. And then either way, you'll be in a good position there if you're able to do that. The level of complexity of this area and the large commercial value in you potentially getting it right for your business do mean, as I say, that it's recommended to get legal advice on this. And so if you'd like an initial discussion on it, please do get in touch with us at Sheridan's and the Sheridan's data team. And if you'd like that, then Ukie, I'm sure, can connect you directly with us if that's helpful. And if you have any questions for me today, do post those in the chat and I'll try my best to answer them. that's it from me for now.
Great, thank you so much, Liam. We will now move into the Q&A portion. So thank you everyone who's submitted one so far. Again, feel free to continue to submit them as long as there's time. So the first question we have is, does the SOC code 2136 cover anyone working within software development, such as artists, musicians, producers, or is there only software engineers? Kelvin, do you know the answer to this, and could you share it with us?
Yes, so the answer is it doesn't cover all of them. So basically that was, I guess I gave that as an example, and one that I thought was kind of good news. Artists are kind of a separate occupation classification code, and at the moment are also listed on the shortage occupation roll. Musicians, to my understanding, are not currently listed on the shortage occupation roll as a shortage occupation, sorry. Now, the sort of distinction between shortage and non-shortage occupation now is not anywhere near as significant as it used to be under tier 2, in that it used to give you an exemption from the resident labour market test, which was, made it significantly easier and gave a lot more certainty about being able to recruit people in those roles. Now that the labour market test doesn't apply, it really just means you're paying a slightly lower government fee and may benefit from a slightly lower minimum salary. The other thing to add is this list is continually updated based on sort of data received by the Migration Advisory Committee and their recommendations to the government. So even what's on there now, it's worth kind of continuing to review it rather than sort of placing too much reliance on what the list says now, in 6 months or a year's time. Hopefully that answers it.
Great. Secondly, so to meet the 31st December deadline under the current immigration rules, do EU employees have to be living in the UK or just full-time employed by the UK-based company?
So to be eligible under the scheme, they need to actually enter the UK before 11 o'clock on the 31st of December to be eligible to apply. There are some separate provisions being introduced for frontier workers who are working in the UK but based overseas, but again, that's for people that kind of are entering the UK to work. So yeah, it's not just about kind of where is their employment contract. If you want them to benefit from the settlement scheme and kind of secure that right to work for the next 5 years under pre-settled status, then we want to get them to physically enter the UK before the 11 p.m. 31st December deadline. And then the evidence they can provide to show that they were here, it can be as straightforward as their flight ticket used to enter, if they haven't yet kind of got things like utility bills and other kind of more kind of established evidence. If they're on UK payroll, they may even be able to evidence their presence through their national insurance number.
Great, we've got lots of immigration questions, just to warn you. I'll do one immigration one and then we can try a few other ones, we can return to this. Someone's asked, our CTO is a German citizen who currently works for us in Switzerland. He's currently unpaid but owes 70% of our company and is looking to move to the UK in January and start earning a salary through pay as you earn. What would be the best route for us to handle him coming to the UK?
So I guess this comes to the sort of point I made before, which is EU nationals, and that can enter the UK before the end of the year and benefit from pre-settled status. That's the most straightforward option because it then gives them the ability to be working in the UK post-Brexit or post the end of the transitional period. If he's coming in from the 1st of January for the first time, then because there's no longer a restriction on owning more than 10% of the shares, sponsorship under a skilled worker visa would be an option. If he's a business owner, you could also potentially look at one of the other kind of routes for business owners like an innovator, but if it's an established company already, it's probably not going to be the most straightforward. And then the other would be the global talent, depending on their kind of profile in the industry. And if we felt that they could qualify for the global talent visa, that gives them that kind of flexibility that I mentioned of being able to either be working as a salaried employee or kind of be an entrepreneur and kind of have more flexibility.
Great, thank you, Kelvin. I've got a question for Liam. So someone has asked, how likely do you think that it is that the UK will receive a data adequacy decision on January the 1st, especially when considering the recent EU-US Privacy Shield case? So in your opinion, how likely do you think it is?
Yes, can you see and hear me?
Yes, perfectly.
I hope that you can. So good. If I break up, let me know and I'll go over it again. So I would describe it as reasonably likely, but not certain that we'll get the adequacy decision. And like a lot of things to do with Brexit, unfortunately, it's hard to say anything with complete certainty, and it's a part of the wider negotiations about what happens on this front, because there's a lot of commercial value involved on both sides. So like I say, reasonably likely, but not certain. There are positive noises being made about this from the UK side, UK entities, but it's not clear exactly where we're going to land. And it's possible that even if the UK does get this, it may take a bit of time yet. And so it might be the case that we get it in the end, but it takes some time and it's not immediate. And so the best thing to do really is to try and prepare as though we're not going to get that. And then you're in the best possible position that you can be.
And off the back of that question, there's been another question asking, what supplementary steps, in addition to standard contractual clauses, can UK games companies take to continue to access data?
That is a tricky question. And what I would say is the best place to start on something like that is to engage lawyers for legal help, unless you have your own in-house team, and then start to kind of do an audit type process of the transfers that are involved in a relatively detailed way if you have a complex business, and decide for yourselves, what is it going to be appropriate here? What are the legal standards that I need to meet? How far do the SCCs go? What other measures might be appropriate? And it might be that you kind of conduct a kind of data transfers risk assessment of what's involved there. And like I say, ideally, you would be engaging legal help for you on that, because it does get quite complicated. And based on that assessment, there could be any number of things that come out as being increase the robustness of the privacy steps there for individuals, and also just help to legitimize your transfer overall, and kind of evidence that you're looking after people's privacy.
Thanks, Liam. We have a question that asks, are digital games classed as goods when considering cross-border sales? So I'm not sure which one of you feels that you're best placed to answer.
Liam, do you want to get it? You've got...
Yeah, sure, if that's helpful.
I mean, I just saw you come off mute, that's all.
Oh, do you want to, maybe I'll leave that one with you, Sally.
No. I mean, you might have something to add, actually, and I know that all I was going to say that, obviously there is a kind of logic to digitally supplied goods if they're downloaded, but there is a Court of Justice reference at the moment about whether electronically supplied software is goods. So there's a degree of uncertainty there. But I think that, what Liam was saying earlier about planning for the worst, it would be sensible to kind of consider them as goods and kind of stress test it on that basis.
Yeah, and to kind of add to that from the data protection side, if you're making a game digitally, say for example, you put your game on the App Store and it's available in multiple territories, from a data protection perspective, you're putting your game out there in multiple territories, and it is relevant to be thinking about these areas.
On a somewhat relevant note, someone has asked, if I'm shipping boxed goods to the UK, do I need to include a UK address on the box? For example, they said they have their Swiss address there at the moment, and changing this for the UK would be quite difficult for them to manage. And this is what's been suggested to them by retail partners. So I'm not sure if any of you can shine some light on this issue.
I think that seems to me to be quite a specific question. I'm not sure if we're able to answer that in the scope of what we've discussed today. But if that individual would like to reach out to Sheridan's, and maybe we can have an initial think about that on our side, maybe offline, and see if we can be of any help there.
Sure. Next, to go back to immigration, sorry, Kelvin. Someone has asked, does someone coming in via the new entry routes have to be new to industry or their job role? I assume this is a new entrant route.
So the new entrant kind of route is basically part of the skilled worker visa, but people that are deemed to be new entrants qualify for basically reduced minimum salary levels. So to qualify, you're either somebody who is switching from being on a student visa, or in the future it will also be from the post-study work visa, or somebody who's under the age of 26 when they apply. As long as they meet those criteria, it doesn't matter kind of how much experience they might have already accumulated. It's based on you either do or don't meet one of the criteria, in which case you can rely on it. Otherwise, you'd be looking at the kind of qualified person rate or experienced worker rates.
And still on the topic of immigration, someone has said on the suggestion to relocate hires in 2020 to make it easier. Due to the COVID crisis, it's obviously quite difficult to do this and to find apartments for expats in 2020. Do you know if is it possible to get pre-settlement status for EU citizens in temporary housing in 2020 still?
So in terms of, I mean, not so much in terms of just the kind of how readily available is housing. I think the sort of key thing is you need to enter during 2020 to make your application for pre-settled status. You don't necessarily need to remain in the UK continuously from that point. Once you begin your period of continuous residence and have pre-settled status, to maintain that, you shouldn't be out for more than 180 days in any rolling 12-month period until you qualify for settled status, or potentially a single absence of up to 12 months for an important reason. So as long as you don't breach that, you could come into the UK for a period of time and just stay in a temporary accommodation, even a hotel or serviced apartment, and then leave the UK, come back in the new year and carry on. And as long as you've kind of commenced that period of residence before the end of the transitional period, you can continue that as long as you're not exceeding those limits.
Thanks, Kelvin. Someone has also asked, if I want to hire someone with a PhD that does not directly match the position I'm hiring them for, will they still receive points in the points-based system?
No, so and I must qualify that the system went live today, so I don't have as much experience as I did under the Tier 2 route, but my understanding is it needs to be relevant to the role, and I think there is a question on the certificate of sponsorship if you tick that there is a PhD to explain why that PhD is relevant to the role. So I think the answer is, it wouldn't necessarily assist.
Thank you. Tim, we've got one question for you. Someone has asked, do you think we'll be able to take part in EU funding after Brexit? I suspect not.
Just unmute myself there. It's highly unlikely at the minute. I think one of the main problems we're having is that we just don't know what's going to be agreed as part of the deal. Based on what we're looking at the minute, it just feels unlikely, because naturally any kind of participation in any kind of EU funding is going to require the UK to join back in or be a part of the state aid rules and the state aid regulations that are currently in place and that will disappear, after the transition period. Those state aid rules have been one of the key sticking points of the Brexit negotiations, in terms of they basically, I guess from the government's perspective, the whole thing that they're sort of seeing about one of the big benefits about leaving Europe is that we can set our own rules in terms of funding. We don't have to be bound by the same rules in terms of distorting competition with other member states. So if we then have to give that up to be, if we have to give that up to be part of the state aid rules for the sake of the Creative Europe funding, I'd be really surprised if the government bit on that. So again, it's one of those things that is TBC without a clear answer. I know that's frustrating, but yeah, sadly nothing clear to kind of determine on that at the minute. But I would be surprised if the UK is allowed to participate in the future.
Thanks, Tim. We've received another immigration on Kelvin. Someone's asked, does the role have to be available, or can they take the role of an existing employee? So I assume, does the role have to be a newly formed one, or does it have to be the role of an existing employee? I suspect it wouldn't matter if you wanted to hire someone.
Yeah, so yeah, basically it needs to be a genuine vacancy. So the role must exist. It doesn't matter that you may already employ people in that particular role. So you're recruiting a second person in that role, or somebody's left and there's now a vacancy. And I think the key thing that people need to make sure is that it's a genuine role that exists. The person will be doing that role, and the person that you're placing into that role is properly kind of skilled and qualified to do the job.
Finally, one last question, and this is for Liam. Is the government providing any support regarding a failed data adequacy agreement, because it's quite unclear at the moment? So do you know if there's any avenues of support available for businesses?
I'm not aware of any support in this area. For example, in terms of any grants or reimbursement of legal costs or things like that, in terms of costs that you might have to unfortunately go through to be able to legitimize your data processing activities. But obviously Ukie are amazing with putting out lots of guidance and support tools in this area. And also the UK's regulator, who are called the ICO, Information Commissioner's Office. So if you have a look at their website as well, or at ico.org.uk, and they are very good as well at providing a lot of guidance notes, a lot of resources, some basic templates. And so if you're not able to incur costs of legal fees, but you do need support, maybe get in touch with Ukie and also have a look at the tools there on ico.org.uk, and hopefully that's helpful. It is a complicated area, unfortunately, and so to prepare in the best possible way, you likely will need some legal support. And if you're looking at doing that, like I say, do get in touch with us at Sheridan's, and we'll try our best to help as well.
Amazing. So we've now reached the end of our webinar. I hope this was helpful for everyone who's come and watched. Like I said earlier, we'll be showing the presentations that were shown today. And also there will be articles uploaded to our website in due course that goes into more depth on each of these topics. If you have any further questions, always feel free to reach out to us at Ukie. You can reach out to me at grace@ukie.org.uk, or the general Ukie email, hello@ukie.org.uk, in case it's something not specifically related to policy. But other than that, I hope you all have had a wonderful time listening to our wonderful lawyers, and thank you for attending again.